adventure in that sense.
Yeah.
Jocelyn, you never responded to me.
What?
My meeting.
Which one? Oh, the Seinfeld one. Oh, right. I'm sorry.
Come on, that was a quality
It
performance.
was. I laughed. I guess my mind was like somewhere else and I forgot to respond.
I think all of our minds are something else. Multiple locations. Let's see, we're in the finals of the tournament. There's a major pandemic going around. There's plenty of other things to worry about.
Myerowitz perfect. You get that if you were about this.
I just didn't want to be on the camera.
Oh, okay.
Am I on the camera?
Yeah.
I
I don't know.
No, you're right under. You're right under.
No, there's one over there.
Yeah, there's one right here.
Yeah, but
See,
you're
on
not.
all angles.
So then, just like in the Court of Appeals, you always want to sit on the left side of how they start.
Well, I just don't
Where
want.
would you?
Put the chair.
Welcome everyone. As I don't know, I'm a piece of manufacturing advisors. I just wanted to welcome you, congratulate you all for being here. Great job, and I'm so sorry we can't have friends and family here with you today, but I know you'll do awesome, even if they're watching on the web. So,
Thank you.
congrats.
Thank you.
Sounds good. Yeah. Yeah, the way I did it, just not even looking at the notes. That's my voice.
Same thing.
Good to go. You guys good to go?
Yeah.
Cool. Good luck. Thank you.
morning, everyone. Please be seated.
Good afternoon and welcome to the final round of the 2020 Myerowitz Moot Court competition. My name is Brian Reed and I am president of the Moot Court Board. We have a very exciting final round planned today with a distinguished panel of judges and some very talented competitors. I'm going to go over the program today, but first I'd like to recognize the chairs of this competition and Professors Graber and Sweeney. Our co-chairs wrote a very interesting and challenging problem, worked through every step of the brief grading process, and oversaw the competition's oral arguments. Having done a fraction of that work myself, I can tell you that this is no small task and they deserve a hand. Now for our program today. You will first hear from our Dean, Dean Donald Tobin, who will give some introductory remarks. Next, Myerowitz competition co-chair Bianca Spinoza will give a recitation of the facts and the record from which our competitors will be arguing today. After this recitation, our Vice President, Kellen Wilcox, will introduce the competitors and the presiding judges. Each competitor will have 15 minutes of oral argument, with the petitioners reserving time for rebuttal. After our oral argument, the judges will deliberate, during which we will take time to announce the new members of the Moot Court Board. Once the judges return, they will provide feedback to our competitors, announce the winners of Best Oralist, Runner-Up Best Oralist, Best Brief, and Runner-Up Best Brief. Professor DeSimone will give closing remarks. The entire Moot Court Board thanks you for tuning into our live stream.
Hello and welcome everyone. Welcome everyone on the live stream. I'm Donald Tobin. I'm the Dean of the University of Maryland Francis King Carey School of Law. First, I want to apologize to those of you who have to watch this on live stream and to our panelists. We obviously have had to make a lot of decisions over the last couple of days about how to continue our operations while minimizing the risks of the coronavirus. And so today, we are going to be having our audience and others watching only in live stream. I would say to you as a former litigator, especially as an appellate litigator, there were many times where my courtroom looked like this when I litigated because no one but me was interested in the case. And so it's going to be, I think, a little awkward for all of us, but I appreciate everybody hanging in there and moving forward. And I think you'll all have a great story to tell about your Myerowitz finals that is different than everyone else's. I do want to take a moment, though, to talk a little bit about Myerowitz and hope the people who are on the live stream are getting that information as well. This is an incredibly important competition here at the law school and one that really allows us to showcase some of our amazing talent. And as I said, as a former appellate litigator, I did this for a living. The first time I argued a case was in the Eighth Circuit with no moot, no practice, no Myerowitz. And let me tell you, that was not the best argument I've made in my entire life. And so I think being able to engage in these kinds of competitions and being able to practice this skill is really important. And one of the things that I've learned over the years is that you do this far better than I would say 90% of the lawyers that I litigated against or saw when I was a clerk. That the amount of time and effort that you put into these cases, the practice that you put in, really do put you at that highest level. And I really want to encourage you as you move forward in your careers to think about that level of work. To be a great litigator, to be a great lawyer, it requires deep commitment of time and energy. And you all have shown a willingness to do that, an ability to do that, and an ability to put your game at just that really incredibly high level. So I want to congratulate you for that and really encourage you for that. I also want to take a moment to thank our Moot Court Board and our Myerowitz co-chairs. This takes an incredible amount of work and planning, coordination, and I will say we have lots of competitions that happen, and I really want to call out to the Moot Court group. You do this. I guess I can't say you're the best at this because people are watching back there, so lots of people are good at this, but year in and year out, your commitment to excellence in the competition is really special, and I really want to commend you for that. And so, Brian Reed, I want to thank you for all your work. Kellen Wilcox, as Moot Court Vice President, your organizational structure and the way you make this work is really, really valued, and I really appreciate it. And then to our people who actually make today work, Julian Fearson, Samuel Morse, and Bianca Spinoza, again, we get how much work goes into preparing these things, making sure the cases work, making sure arguments work, and we really couldn't do that without you. It's really a great example of a curricular activity that is a partnership between students in the law school, so I really appreciate that. And lastly, I think there's a real introduction for the judges, but I want to give a special thank you to the judges. I've had the pleasure being dean for 6 years and working with all 3 of these judges very closely in one way or another. You are about to be able to do this competition before, I think, some of the smartest people on the bench. And so I just want to take a moment to thank you all for being here with us and helping the students get the kind of experience that they really want in an event like this, where they're getting to perform and do their work before some of the best people, I think, in the country. So thank you as well. So again, welcome. I hope you enjoy on the live stream. Good luck to the competitors. Thank you to the Moot Court Board, and thank you to my judge colleagues who are here today. Thank you all.
Thank you, Dean Tobin. I'll now introduce the judges. The Honorable Paul W. Grimm serves as a district judge for the United States District Court for the District of Maryland. Previously, he was appointed to the court as magistrate judge, where he served as chief magistrate. And in 2009, he was appointed by the Chief Justice of the United States to serve as a member of the Advisory Committee for the Federal Rules of Civil Procedure. Before joining the court, Judge Grimm practiced private commercial litigation in Baltimore for 13 years. He also served as Assistant Attorney General for the state of Maryland, an Assistant State's Attorney for Baltimore County, a Captain of the United States Army Judge Advocate General Corps, and a Lieutenant Colonel from the United States Army Reserve. Judge Grimm received his undergraduate degree from UC Davis, his JD from the University of New Mexico School of Law, and his LLM from Duke Law School. The Honorable Andrea M. Leahy serves as an at-large judge for the Court of Special Appeals of Maryland. Before joining the court, Judge Leahy served as Associate County Attorney for Prince George's County, where she was lead counsel to the Department of Environmental Resources, Senior Legal Counsel and Director for the Office of Legal Counsel and Regulatory Affairs at the Office of the Governor, and an Assistant U.S. Attorney for the District of Maryland. Judge Leahy received her undergraduate degree from Catholic University and her JD from the American University Washington School of Law. The Honorable Stephanie Gallagher serves as a district judge for the United States District Court for the District of Maryland. She was previously appointed as United States Magistrate Judge for the District of Maryland. Before joining the court, Judge Gallagher served as a law clerk to then Chief Judge J. Frederick Motz of the United States District Court for the District of Maryland, worked as a litigation attorney in private practice in Washington, D.C., and served as an Assistant United States Attorney for the District of Maryland. She also co-founded a litigation boutique handling both civil and criminal matters. Judge Gallagher received her undergraduate degree from Georgetown University and received her JD from Harvard Law School. Our competitors today start with Ms. Jocelyn Brocato. Jocelyn Brocato is an associate editor for Maryland Law Review and currently interns in the Civil Rights Division of the United States Department of Justice. Ms. Brocato is also an academic advising teaching fellow for the current first-year law students. Prior to law school, Jocelyn attended the University of Maryland undergrad, where she became a 2-time national boxing champion in the United States Intercollegiate Boxing Association. Ms. Brocato will be working as a summer associate for DLA Piper this summer. She would like to thank her friends and family for their support, and she would also like to congratulate her exceptional peers who have been selected to join the Moot Court Board this year. Allison Hyde received her bachelor's degree in communication studies and a minor in journalism from the University of North Carolina, Wilmington, and her master's degree in applied sociology from UMBC. She worked in the publishing industry for 7 years before beginning law school. Last year, she was a law clerk at the Maryland Office of the Attorney General in the Civil Litigation Division, and she has been externing for a state appellate judge since August. She's a member of the Maryland Law Review and a writing fellow, where she assists in teaching first-year students in the legal analysis and writing and oral advocacy courses. This summer, she'll spend the first half of her summer in the Office of the Legislative Counsel for the United States House of Representatives, and the second half at Sims, Bowen & Sims here in Baltimore. Kyle Correga graduated from Rensselaer Polytechnic Institute in Troy, New York, with a degree in computer science. He worked as a program manager for Microsoft and an organizer for grassroots nonprofits before coming to law school to pursue a career in civil rights, constitutional law, or public interest. Mr. Correga is on the editorial board for the Maryland Law Review and is a research assistant for Professor Don Gifford. He's an intern for Judge Bennett at the United States District Court for the District of Maryland and has previously worked for Judges Adkins and Getty with the Maryland Court of Appeals. This summer, he'll be working for Gallagher, Aviles, and Jones as a summer associate. And finally, Danny Mooney is originally from Ellicott City, Maryland, and graduated from Loyola University, Maryland, with a degree in mechanical and materials engineering. Mr. Mooney is a member of the Maryland Law Review and the National Trial Team. This coming summer, Danny will be a summer associate at the law office of Robert D. Cole Jr. and Hogan Levels, and intends to pursue a career in litigation following graduation. Danny would like to thank his parents, sister, cousins, and girlfriend for their unwavering support throughout this competition.
Good afternoon. My name is Bianca Spinoza, and I'm one of the Myerowitz co-chairs, and I will be giving a summary of the facts and the problem for today. During the summer of 2019, Will Clark and his daughter, Meriwether Louise, fled Atlantis after flooding devastated the island country. Clark and Louise landed by boat on the western shore of the United States. They arrived in the city of Metropolis in the state of Lucasland. Clark and Louise sought shelter at Metropolis, Maine, a shelter for homeless persons, but there were no available beds there. The staff informed Clark that the only other shelter in the city was also full. Clark and Louise found a group of tents under Jedi Memorial Bridge. Clark and Louise took shelter there for a few weeks as Clark searched for work. On August 6, 2019, Metropolis police officers responded to the bridge after reports of a brawl. Officers arrested Clark and 10 other people sleeping in makeshift shelters under the bridge, charging them with violating the anti-camping ordinance, which criminalized sleeping or camping outdoors on public property. Clark was prosecuted and convicted under the anti-camping ordinance. 3 days before his release from prison, Clark received a notice of intent to issue a final administrative order of removal from the Department of Homeland Security. The notice of intent form gave Clark 10 days to respond to DHS with a challenge to his removal. Clark promptly returned the form, checked the box indicating he wished to contest his removal, and provided a letter requesting a hearing. DHS granted Clark a hearing before an Immigration and Customs Enforcement officer. During the hearing, Clark explained he had no choice but to stay under the bridge. The ICE officer asked Clark if he had made all his legal arguments. Clark responded yes. The immigration officer denied the challenge to removal. Clark appealed to the U.S. Court of Appeals for the 14th Circuit, arguing the anti-camping ordinance was unconstitutional under the 8th Amendment's Cruel and Unusual Punishments Clause. A 3-judge panel held they had no jurisdiction because Clark did not exhaust his administrative remedies. The 14th Circuit vacated the panel decision on the jurisdiction issue en banc and held that under the 8th Amendment, the city cannot criminalize sleeping outdoors when no sleeping space is practically available in any city shelter. The Supreme Court of the United States granted certiorari on both issues.
Good morning. You may begin.
Madam Chief Justice, may it please the court. I'm Kyle Correga for the U.S. government and the City of Metropolis on the jurisdiction issue. Your Honor, this case is about separation of powers and individual responsibility. Today we ask this court to reject a constitutional claim that was never raised through the required process and to overturn a decision with serious implications for our immigration system. There are 2 reasons the ruling of the 14th Circuit should be reversed. First, this act makes issue exhaustion a jurisdictional requirement and does not contain an exception for constitutional claims. And second, exhaustion is necessary here to promote judicial restraint and to preserve the integrity and effectiveness of the immigration process.
Do you recognize as part of separations of powers, Mr. Correga, the difference between the power of the judiciary and the power of the executive?
I do, Your Honor.
And let me ask you this. This was a hearing before a DHS enforcement officer, is that correct?
That is correct, Your
And
Honor.
this is a expedited removal proceeding, not one before a immigration judge, is that right?
That is correct.
Tell me, please, what is the legal training of a DHS officer, enforcement officer, for purposes of determining legal claims or challenges as opposed to factual ones? Tell me what they're trained, how they're doing that.
Your Honor, the ICE officer most likely had no legal training. However, if it is required under regulation that if an individual is not amenable to the expedited removal proceedings, the officer must transfer them to a hearing before an immigration judge. Had this claim been raised in the proper forum, had Mr. Clark properly litigated his claim through the required...
How would they know whether that person is amenable or not if that person doesn't have counsel or doesn't have the opportunity to know that they're supposed to raise legal as well as factual questions?
Your Honor, I see two parts to this question. The first is how would Mr. Clark, how would the respondent have known that he could have raised a legal claim? And the second is what the standard for amenability is. Which would you like me to address?
Whatever order you want, sir.
Sure. So to the point about Mr. Clark's knowledge, we sympathize deeply with the struggles that immigrants face when they come to this country. But individuals who take part in our legal system and are subject to legal process have a responsibility, an individual responsibility, to avail themselves of the opportunity for relief. And here, the government recognized the hardship that immigrants face and, in fact, provided the opportunity for immigrants to obtain counsel. The form lists as a right and responsibility of the recipient that they should obtain counsel and provided a list of available free legal services to do so at no cost.
Well, what if Mr. Clark wasn't able to obtain counsel within 10 days? Is there anything on the notice that says he can request a postponement?
Your Honor, first, to be clear, this is not a 10-day time period. First, if he returns the form by mail, the period's extended to 13 days by regulation. And second, the hearing was not scheduled until a little over 2 weeks after he had returned the form on October 7th. So he had something approximating 3 weeks to obtain counsel using any of the free services that were provided. And there's nothing in the record that suggests he either didn't understand the process to obtain counsel or that he had tried to and simply failed. It's also important to note that these are immigration procedures, and this court has consistently described congressional authority in the immigration process as plenary. In fact, there is no due process right to counsel in these proceedings. The right to counsel that exists is entirely a creature of statute, and it's provided because the government is aware that immigrants need representation so that they can properly exhaust their claims and properly raise the necessary issues through the correct legal channels. Had Mr. Clark availed himself of this request, a request that there is nothing in the record that suggests he did not understand, and had he obtained counsel, he would have been able to go through with the necessary process and exhaust his claim. In this situation, Your Honor, as in our criminal justice system, ignorance of the law is no excuse. If an immigrant can simply decline counsel and then claim that they did not understand the consequences of these procedures, the department's authority will be rendered toothless. It will be very easy for any immigrant to take advantage of this loophole in the system and fail to comply with the necessary process and resort directly to the court.
Didn't this gentleman, though, fundamentally try to raise his issue? He may not have used the words that an attorney would have used, but he checked off that he was contesting the proceeding, and then at the hearing, he said, I did not want to sleep under the bridge, but there was nowhere else for me to go. Didn't he effectively raise the issue, although, again, not using legal terms?
Well, Your Honor, I do agree that, and it's undeniable from the record that he discussed that he had nowhere else to go and he had nowhere else to sleep, but that's not the same as presenting an Eighth Amendment claim. The standard for issue exhaustion that's been developed in cases like these is usually not just that there's a possible basis for the issue on the record, but that the issue is mentioned directly and that the department at least has an opportunity to develop it. A key example for this is Sunoto from the court's indulgence for a second. Sunoto from the First Circuit in 2007. In that case, an individual raised a claim before the immigration officer that that it was unfair for the immigration judge to call them a liar. And then on appeal, they tried to officially argue administrative bias and due process. And very similar to the situation here, the appellate court found that, that simply raising a fact that could suggest a legal claim is not enough. And that's because if that was our standard for issue exhaustion, simply put, it would be very difficult to serve the underlying purpose of the doctrine and the objectives that Congress put in this act when it imposed this requirement.
Well, let me ask you.
No, go ahead.
Judge Wren, in his decision, acknowledged that under Thunder Basin, the hearing officer, wouldn't have the ability to conduct a constitutional analysis of the statute, right? So, I mean, why wouldn't it have been futile to even raise the constitutional issue before the hearing officer?
That's correct, Madam Chief Justice. We do not contend that this agency could overturn the city ordinance, but I'll respond to that answer in two parts. The first is that this is a jurisdictional requirement, and as this court has repeatedly held from McCarthy to Sims to recently in Blake v. Ross in 2016, when Congress requires exhaustion, the court cannot judicially craft exceptions. Second, to the point about futility, exhaustion actually serves a fundamental role as a doctrine of constitutional avoidance. That gets to the second part in my core framework here. Simply put, there's a basic separation of powers principle that constitutional decisions are dramatic forms of relief and are meant to be decisions of last resort. And so requiring exhaustion in a case like this that is as applied and fact-dependent both defers to the agency's expertise and avoids reaching an unnecessary constitutional decision when relief could be granted on other grounds.
So help me out. You make a great deal of the statute that requires exhaustion. What is the exact language of 8 U.S. Code 1252D1, the language of exhaustion?
So 1252D1 provides that an alien must exhaust all administrative remedies available as of right.
All right, and where in that does it say that those administrative remedies have to specifically include legal or constitutional claims as well as fact claims?
Well, Your Honor,
tell me where the language says that specifically. It doesn't, does it?
In that particular clause, it does not. However, both the history of that clause suggests that Congress did intend to include issue exhaustion, and more importantly, we're not dealing with one clause, we're dealing with an entire statute. 1252B4A provides that reviewing courts can only make decisions based on the contents of the administrative record. And that is a jurisdictional constraint, and it mirrors the language that's used in other statutes like this. And 1252B9 directly provides that no court will have jurisdiction over questions of law or fact that are not raised in compliance with these procedures. Those three provisions together clearly create an issue exhaustion effect. If an issue is not argued before the agency and is not a part of the administrative record, it is unavailable for us to consider on appeal.
So, go ahead.
Well, I mean, wasn't the factual evidence that was presented sufficient to support an Eighth Amendment claim? I mean, he said that he would have never stayed under the bridge if he knew that fights would break out, that he had nowhere else to go with his daughter, and that he was just sleeping there so that he could search for work and make a better life for himself. Wouldn't it be obvious that punishing someone for that, it would be a violation of the Eighth Amendment?
Well, Your Honor, to the substance of the Eighth Amendment, I will leave that to my co-counsel to discuss. As for the sufficiency
But
of...
I'm just talking about the facts underlying the constitutional claim were certainly presented to the hearing officer.
Your Honor,
Certainly enough, didn't he fail to refer it to the IJ?
well, Your Honor, the facts were presented, but the legal theory was never mentioned. And that's a critical difference here, because if the litigant does not raise the appropriate legal theory and does not develop it, as in Sonoto, the agency really has no understanding of what it's dealing with. That's the reason we have these issue exhaustion requirements. It's so that individuals can develop a proper understanding of the record, and that the agency can have a full understanding of the issue, apply its expertise, and have the chance to grant relief. There's a great example of this in Elgin versus Department of Transportation, a decision this court decided in 2012. In Elgin versus DOT, a series of litigants were fired from their administrative jobs for failing to register for the draft. They went through the whole merit board process, and then only when they reached the appellate level did they argue that the Selective Service Act was unconstitutional as applied. This court nonetheless found that they failed to exhaust their issues. Simply put, had they developed their due process claim at the agency level, even though the agency had no authority to overturn the statute, the underlying facts that would have emerged and the development of those issues could have allowed the merit board to apply its own expertise and grant them reinstatement on the basis of constructive discharge. We have the same situation here. If he had gone beyond simply mentioning in a basic form that he had nowhere else to stay, just as if the litigant in Sonoto had gone beyond mentioning that it was unfair for the judge to call him a liar, the ICE officer would have been required to transfer him to an immigration judge. They could have developed the theory more fully, and the agency would have had the opportunity to provide its relief on its own grounds.
But yet the form that's used doesn't have a box or a place for anyone to indicate that they wish to raise a legal issue.
Your Honor, I'd say two things to that. The first is that a layperson looking at this form, I would contest, won't know the difference between law and fact. Certainly for many of us, before we began our legal educations, that term of art was not something that was kind of within our conscience and wherewithal. But second and more importantly, there are legal issues on this form. The validity of the conviction as a violent felon, the citizenship status, especially given that his country may have been destroyed and he may not have existed. Those are issues that are at least in part law, and a reasonable person who believes their conviction is unconstitutional would challenge the constitutionality of the conviction by challenging the validity of their conviction as a violent felon.
So don't the DHS regulations that talk about what the authority of the enforcement officer is, 8 CFR 238.1 D2, Romanet 1 and 2, authorize the enforcement officer to determine whether or not a challenge to removal raise a genuine issue of material fact in the NOI form. If you're so convinced that the agency provides an opportunity that is non-futile to a party that is facing removal to raise both legal as well as factual arguments, then why is it that your own regulations restrict the authority of that very officer to determinations of material fact as opposed to legal issues?
Your Honor,
if it was a court proceeding, the two-part standard for whether summary judgment is a genuine dispute of material fact and not entitlement as a matter of law, why is it that by focusing on the fact aspect of it and ignoring completely determination as a matter of law that the agency hasn't essentially done exactly what Justice Leahy has suggested that they've done?
Your Honor, I see my time has expired. If I can answer your question and then conclude.
Sure.
Simply put, you're referencing the decisions in Valdivia v. Holder and Etienne versus Lynch.
No, I'm referencing the Code of Federal Regulations.
Right, but simply put, that is not a full look at the regulations. Yes, you are correct that that particular provision requires decisions based on fact, but the statutory standard for review of a decision for removal is whether it's manifestly contrary to law, and the regulations directly provide one paragraph above that the notice of intent will include both allegations of law or conclusions of fact and allegations of law. For these reasons, Your Honor, this court should reverse the decision of the 14th Circuit in its entirety. Thank you.
Thank you.
Thank you.
Good afternoon, I should say, Ms. Hyde.
Good afternoon, Your Honors. May it please the Court. My name is Allison Hyde, and I represent the petitioners, the United States government, and the City of Metropolis on the Eighth Amendment issue. Your Honors, the Eighth Amendment has not been a static concept, but one that has evolved with society's moral values. This case is about recognizing the distinct roles of the legislature and the jurisdiction in relation to that concept, and their effect on local government's exercise of their police powers. This case presents the court with an apparent choice between two discrete analytical paths. And although we, the government, urge the court to adopt a path that does not force it to stand in the shoes of the legislator, This court will find nonetheless, under either path, that it must reverse the 14th Circuit and find that the anti-camping statute is constitutional.
Was there any breach of the peace involved in the circumstances in which Mr. Clark and his daughter were in the underpass at the camp?
Your Honor, it was reported that evening that there was a brawl.
Did his conduct, was he specifically involved in any breach of the peace?
Your Honor, the record indicates that he was not. It indicates that he was sleeping in the encampment, but what he was arrested for was still a violation of the anti-camping statute.
But that's not my question. Was he found to have committed any assault or any theft?
No, Your Honor, he was not.
All right. And were there alternative places where he could have stayed?
Your Honor, this is one of the key points to this case, and in one that essentially...
Perhaps you could answer my question before giving me your further explanation.
Sure, Your Honor. The record does not demonstrate that whether there were other places or available shelter on the night that Respondent Clark was arrested. In all the cases that have assessed statutes prohibiting or criminalizing sleeping outdoors on public property, when the court has rested its determination on whether that conduct was voluntary or involuntary, it's done so on a record that either provided unrefuted evidence on the availability of shelter space on the evening or morning that the person was convicted, or in a circumstance where where the number of homeless people in a jurisdiction so far exceeded the number of available shelter spaces that the court was able to say with no issue that at any given point in time, homeless persons in the area were not able to get shelter space. And we have neither of those things here. What we do know is that in January of 2019, so 7 months before Clark was arrested under the statute, there were 700 some homeless people in the city of Metropolis, 63 of whom were unsheltered. We don't know why they were unsheltered. We don't know how many available shelter spaces there are at the 2 shelters in Metropolis. We still don't know those facts for the night that he was arrested. So in the absence of evidence that satisfies either of those standards, this court cannot hold that the anti-camping statute as applied to Clark is unconstitutional if it chooses to adopt a holding that says that involuntary conduct can't be criminalized.
Well, the only record we have that we show about what those facts are facts that support Mr. Clark. He said that he had nowhere else for him to go. That wasn't rebutted, was it? There was no evidence to the contrary that was part of what the immigration officer based his decision on. So why isn't it sufficient to us to discern when he challenged what his conviction was and said he had no place else to go? He had no choice but to stay under the bridge. And why isn't that evidence of the fact there was no place else alternative for him to do so?
Well, Your Honor, my first response to that, and I'm cautious not to tread into the first issue of issue exhaustion, but it is normally at the trial level that the factual record is developed around the relevant issues that are raised, and because the constitutional claim was not articulated there, the government did not raise or introduce all evidence that might have been relevant or helpful to this case.
Was there, at the proceeding before the immigration enforcement officer, was the department represented by counsel?
Your Honor,
because you just said the government didn't have the opportunity to raise all the facts. That suggests that there was counsel for the department at that hearing, was there?
Your Honor, no, there was not, but...
Well, then how could the government have ever done that? Are you saying that the enforcement officer's obligation was to act as both prosecutor and adjudicator?
Well, Your Honor, if the issue had been raised, it could have been brought before an immigration judge, and at that point, the government might have introduced evidence on the Eighth Amendment. But we're left to deal with the record that's before us, and because statutes and ordinances are presumed constitutional in the absence of evidence that that conduct was involuntary, there's nothing else for this court to do but to leave the statute undisturbed. And so if I may continue to essentially what the government argues today is that the court should not expand the constitutional doctrine into holding that conduct that is involuntary may not be criminalized. We should lean on the law that is in Robinson versus California, where this court held that a statute criminalizing mere narcotic addiction as a status was unconstitutional and that it violated the Eighth Amendment. But what the respondent and what the 14th Circuit did was apply Justice Powell's narrowest grounds opinion in Powell versus the state of Texas. And that's where Justice White explained that he would uphold a statute criminalizing public drunkenness in the case of the petitioner Powell because the record did not demonstrate any evidence that he was that he could not avoid going out in public. And so we've got the same situation here if this court chooses to go down that road, as I explained, but the government argues the court should not go down this road.
But aren't you asking us to assume that he did have somewhere else to go?
Your
You're
Honor,
saying the record doesn't show one way or the other, but by virtue of that argument, you seem to be suggesting that he does have a choice in the matter.
well, Your Honor, the government is not suggesting that you find that he had somewhere else to go. The government is just saying that if you decide to adopt the position that the Eighth Amendment prohibits criminalization of involuntary conduct, even on that course of review, which this court has not adopted before, it cannot find on the record that sleeping outdoors on public property was truly involuntary for Clark. There's an absence of that evidence. But the government urges this court to not even go down that road and to instead stick to the rule that the Eighth Amendment prohibits criminalization of status only. And the anti-camping statute does not criminalize status. It criminalizes the act of sleeping outdoors on public property.
Isn't that a distinction without a difference? If the status is homelessness, if you have no money is there any evidence in the record that showed that he had money to have afforded a hotel or an apartment or a Airbnb? There's no evidence of that. So why is your distinction a distinction without a difference? It's the status of being homelessness. If you can't afford to have a home, then that's a status, right? If you don't have the money to afford a home, and if there's no Good Samaritan to offer you one, and there's no available shelter in the city, then you have no volition over that. You are in a status. The status is you lack the funds to have a place to stay, and therefore you are homeless. How is that not a status?
Well, Your Honor, the anti-camping statute does not exclusively target this behavior for homeless persons. It targets for everyone, regardless of status, sleeping outdoors on public property. This is different from a case like Manning versus...
So cite the case for me that says that if it's so overbroad that it does punish status as well as non-status offense, that somehow saves it. If the application of this is to someone who is in a status and is being applied that direction, then why isn't that?
Well, Your Honor, in the case of Manning versus Caldwell, the Fourth Circuit won, but the Fourth Circuit limited its holding to the fact that the plaintiffs only argued that the statute was unconstitutional and that it expressly prohibited them from engaging in conduct that was otherwise legal for the rest of the drinking age general population. That's not what this statute does here. The statute prohibits conduct for everyone. And if this court decides today that even statutes that don't target a particular status, even if that activity is normally or most often engaged in a certain class of persons, you're effectively taking away the state's police power. It's, not for the court, as Justice Stewart said in Robinson, to assess the wisdom of how a local jurisdiction decides to regulate threats to public health and safety. So, what I would suggest to the court is that instead of treading into Justice White's narrowest ground opinion, which causes this court and every other appellate court to engage in an extensive fact-finding exercise, which will essentially become subjective, it will put the court in the place of the legislator in assessing moral value judgments, which is a position that the legislator is best equipped to be in.
Well, I have a question. Why was it necessary to make it a felony? Well, I mean, if there was some kind of a reason to try to deal with this problem with people camping on public property, wouldn't it normally just be a simple infraction or a civil fine? This is a felony? It's not even a misdemeanor. Why is it a felony? Aggravated felony.
Your Honor, this reflects the judgment of the city of Metropolis and the extent to which they need to attempt to deter sleeping outdoors on public property. And again...
But going back to Judge Grimm's question earlier, I mean, what occurred? What justification was there for the municipality to exercise police power in this manner Were there any violent uprisings by these people who sleep under the bridge?
Well, Your Honor, the record does indicate that prior to, in that very same encampment, there had been illicit drug use, there had been violent brawls, and so that is the type of behavior that had occurred there. And so if the city made its own judgment that that behavior was occurring more often when persons were sleeping outdoors on public property, it was within their discretion to decide on that enforcement measure. And as soon as the court attempts to step in that role, it will never end. It will be an onslaught of challenges to all different types of conduct and statutes, and the court will become essentially the arbiter of criminal responsibility. So I see I'm running short on time. If Your Honors have no other questions, may I conclude?
Thank you.
Out of respect for the principles of separation of power and federalism and the sheer lack of factual development in this case on the issues that are most critical to Respondent Clark's Eighth Amendment argument, we ask this court to reverse the 14th Circuit and hold that the anti-camping statute is constitutional. Thank you.
Thank you, counsel. Good afternoon, Ms. Brocato. You may begin.
Good afternoon, and may it please the court. My name is Jocelyn Brocato, and I am here on behalf of the respondent, Mr. William Clark, for the administrative exhaustion issue. This case is about a simple concept. If you're going to require someone to do something, you need to tell them. The government cannot impose a duty on Mr. Clark to raise a legal challenge during expedited removal when that duty is nowhere to be found in the statute, in the regulations, or in the notice of intent. This court should affirm the decision of the 14th Circuit for two reasons. One, Mr. Clark was not required to raise his legal challenge during expedited removal, and two, Mr. Clark did raise his legal challenge. When a statute is ambiguous, the Supreme Court case Chevron deference requires the courts to defer to an agency's interpretation of a statute. Now, when you look at the regulations in the Code of Federal Regulations, Section 238.1 mandates that the notice of intent shall include conclusions of laws. But that is the notice of intent. That is not the response to the notice of intent. If you look at the requirements for the written response, the word legal or law does not exist anywhere in the requirements for the written response. In fact, the only thing that the non-citizen must do is say whether he is rebutting any of the factual allegations in the written response, and if so, say which allegations he is rebutting. Mr. Clark does not rebut any of the allegations in the notice of intent. He does not rebut the fact that he was convicted of an aggravated felony, and he does not rebut that he is not a citizen of the United States.
Yes, but in this case, he had a hearing, right? He had the opportunity to make the argument. He could have made any argument he wanted.
Yes, Your Honor, while he may have had the opportunity to make the argument, that does not mean he was required to. And there is not a single phrase in the statute, in the regulation, or in the notice of intent that required him to state his legal challenge. And in fact, while he may have had a hearing, this was not a legal proceeding. Looking at the regulatory history of expedited removal in the Federal Register, the purpose of expedited removal is to be able to quickly deport non-citizens without due process. It is not a legal proceeding. It is an alternative to a legal proceeding. And Mr. Clark cannot be expected to raise a legal challenge when he was not put on notice that he needed to.
So are you suggesting that even someone who had counsel, they could choose not to raise the legal issue during the administrative proceeding and save it for federal court down the road?
Yes, Your Honor, because if someone is not required to do something, then they cannot be expected to do it. This all boils down to my one simple concept. If you're going to require someone to do something, you need to tell them.
But how is that not an invitation to just sandbag, as Judge Gallagher's question says? If you have counsel and you have someone who knows the distinction between law and fact and is an advocate trying to persuade the decision maker and purposely, why isn't that invited error? Why is that something that they should be allowed to do? And why is that a proper and efficient way of dealing with these when they're supposed to be done on an expedited basis?
Your Honor, That is an excellent point, and what I will say to that is that I'm not saying the agency can't require non-citizens to raise legal challenges in expedited removal. What I'm saying is they haven't made that requirement yet, and they cannot expect a non-citizen to raise a legal challenge when there is not a single phrase in the statute, the regulation, or the notice of intent that requires the person to raise a legal challenge. Now, I'd like to point out the authority of an ICE officer under Section 287.5 of the Code of Federal Regulations. An ICE officer's duties, in part, are to arrest and transport people, conduct searches, and execute warrants. Nowhere in those regulations does it say that an ICE officer can decide legal issues. And to reverse the 14th Circuit's decision would be to hold that an ICE officer has now a duty to recognize legal challenges when they have had zero legal training and this is not a legal proceeding.
But don't they have sufficient training as anticipated by the statute to recognize such issues and then refer the matter up to the immigration judge? Isn't that the process?
The process, Your Honor, of the expedited removal proceeding is for the ICE officer to determine whether there is any factual allegations that are being rebutted, because that is what the agency has the authority to determine. And while, yes, the legal proceeding in the formal removal process does allow immigration judges and the Board of Immigration Appeals to decide legal issues, Mr. Clark does not have a right to be in front of an immigration judge. He does not have the right to administrative appeal. He does not even have the right to a lawyer. So when this is completely distinct from a legal proceeding, and there is nothing in the regulation that requires Mr. Clark to raise the legal challenge, this court cannot expect Mr. Clark to raise that legal challenge. And in fact, when deferring to an agency under expedited removal, as I said, there is no right to an administrative appeal or an immigration judge. And also, the Supreme Court recognizes an exception to administrative exhaustion for legal or constitutional issues that the agency is incapable of resolving in McGee versus United States. And in fact, 8 U.S.C. Section 252A2D says that nothing shall be construed in this act as precluding review of constitutional claims or questions of law raised upon a petition for review. That shows that the court is not precluded from deciding an issue, whether it is legal or constitutional. And when we defer to the agency's interpretation in the regulation and in the regulatory history, this was not meant to be a proceeding where people parse out legal issues and decide questions of law. And furthermore, whether the anti-camping ordinance violates the Eighth Amendment has nothing to do with the administrative process. It has nothing to do with the administration's procedures. It has nothing to do with the facts of Mr. Clark's own expedited removal process. So there is no reason why the agency needs to even build an administrative record for the court, because the facts listed in the notice of intent have nothing to do with the Eighth Amendment and whether the anti-camping ordinance violates the Eighth Amendment.
Yes, but wouldn't it frustrate the requirements of administrative exhaustion to just, I guess what you're advocating is people could just clog the courts without the agency ever reviewing these issues by simply attaching to their NOI a little sentence that says, I want to make a constitutional challenge to the statute. After a while, everybody catch on, and that's what everybody would do, right?
Your Honor, going back to what I said before, I'm not saying the agency cannot require people to raise legal issues in the expedited removal process. The agency has the authority to enact a regulation to say that you must raise a legal challenge in expedited removal. What I'm saying is they haven't done that yet, and therefore they cannot require Mr. Clark to raise his legal challenge at this stage. And furthermore,
but if the agency doesn't do that, the courts are just stuck? I mean, people can sort of use the administrative process, as I said earlier, intentionally not raise the issues even if they are represented by counsel and then bring it to court every time?
Your Honor, correct. If the agency does not create a regulation mandating someone to raise a legal challenge in the expedited removal process, then yes, people could bring their legal challenges in the federal courts. And while, yes, that may cause a lot of cases to get to the federal courts, at the end of the day, the Constitution does not die at the altar of judicial economy. And therefore, that litigant should still be able to bring their constitutional claims in the federal courts when the agency does not prohibit it. And going on to my second point, Clark did raise his legal issue. He contested his deportability when responding to the notice of intent. At the hearing, and he followed the 10-day period, at the hearing, he told the ICE officer, quote, "I have nowhere else to go. I had no choice but to violate the ordinance." And based on these statements, Mr. Clark made statements that were tantamount to an Eighth Amendment challenge. What he was saying was that to deport him would be a cruel and unusual punishment for his offense. And just because he didn't say the magic words, cruel and unusual punishment, does not mean that that is not the issue he was raising. If the police come to my house and they don't have a warrant, and I say, "You can't come in," I've raised a Fourth Amendment issue. I don't need to bring out the Constitution. I don't need to cite to the Constitution. I've raised a legal issue. And having an obligation to raise a legal issue does not mean you have to say specific words. The petitioner is faulting Mr. Clark because he didn't say the magic words, cruel and unusual punishment. Well, the notice of intent didn't include the magic words, state a legal challenge. Furthermore, what about the purpose of the notice of intent so that the agency can develop a record? As I was saying before, whether the anti-camping ordinance violates the Eighth Amendment has nothing to do with the administrative record and has nothing to do with the fact-finding process at the administrative level. And again, I would say that this is not a legal proceeding because, as I was saying before, looking at the regulatory history, there is no requirement for the litigant to have due process in expedited removal. He has no right to an administrative appeal, no right to be in front of an immigration judge, and no right to any kind of due process that would be a requirement in the formal removal proceedings. I would also point to the case Etienne v. Lynch, where the court decided that that the non-citizen was not required to raise his legal challenge and that he had exhausted his administrative remedies. Looking at the evidence, the court determined that it was geared towards resolving issues of fact. And that is the same thing that is happening here. If you look at the notice of intent, there are multiple checkboxes that say you can rebut the allegations of fact. There is not a single phrase that says that the person has to raise a legal issue.
So let me ask a question. In the government, in its argument, has made the point that it provides information to each alien facing these expedited removal proceedings of the name and contact information of counsel who will, for no cost, represent them, and the scheduling of the hearing and the period of time from the completion of the form and the time of the actual hearing was several weeks. If your concern is somehow that the proceedings force the alien into a battle of wits unarmed, and that it's an unfair proceeding without knowledge of the distinction between facts and law, then why in the world wouldn't your client have taken the opportunity to avail himself of the opportunity to have counsel free of charge? Why wouldn't he do that? Why didn't he do that?
Your Honor, I'm not saying that expedited removal is an unfair proceeding. I'm not attacking the procedures of expedited removal or even saying that...
Well, why don't you answer that question? Why didn't he get a counsel when he had the opportunity to get one for free, readily available? Why didn't he take it?
Your Honor, although he could have taken that opportunity, he was not required to.
Well, that's not... I didn't ask you whether he was required to. I said, why didn't he?
Your Honor, I do not know why Mr. Clark did not get a lawyer in this case. However, as I was saying, just because he had the opportunity where he could have gotten a lawyer or maybe he could have raised his legal challenge doesn't mean he was required to. This is not a case where the petitioner can hide the ball. This is not a case where the petitioner can put a clue in the notice of intent and Mr. Clark is expected to solve the riddle. If the agency wanted Mr. Clark to raise a legal challenge and wanted to require him to raise a legal challenge during expedited removal, then they needed to put a phrase in the notice of intent, state any legal challenges. That they have not done so and that there is not a single thing about the law or legal challenges in the requirements for the written response shows that the agency does not intend expedited removal to require the person to bring up a legal challenge. And so to conclude, as I was saying before, this court should affirm the decision of the 14th Circuit because the expedited removal process does not require Mr. Clark to raise legal challenges, and 2, Clark did raise his legal challenge. Thank you.
Thank you, counsel. Good afternoon.
Madam Chief Justice, and may it please the court, Daniel Mooney on behalf of Respondent Will Clark on the Eighth Amendment issue. Your Honors, cities should not be able to criminalize involuntary actions because doing so unconstitutionally criminalizes status. This court should affirm the 14th Circuit's decision on the Eighth Amendment issue for 2 reasons. First, the anti-camping ordinance criminalized Mr. Clark's involuntary action of sleeping in public, which is in direct contravention to this court's decision in Powell.
So I have a question, Mr. Mooney, on that, if you might be able to help me out. Is it your argument that if the statute imposes a penalty for involuntary actions, that that constitutes an Eighth Amendment violation?
Yes, Your Honor.
All right. So here, the involuntary action is having a place to sleep. At some point, you got to sleep. But if we extend the argument that you have just made, then by the same token, if someone defecated in public or urinated in public, and that was a clear health and hazard, hygiene hazard, and that was penalized, then why wouldn't that also equally be a involuntary function that was being penalized? Where is there the line that can be drawn to distinguish between conduct which, would you, under your argument, are you saying that if an ordinance said that a person could not defecate in public or urinate in public and made that a criminal offense, that that would be unconstitutional in the Eighth Amendment?
Your Honor, it depends upon what is offered from the specific jurisdiction where that statute is active. For example, if there are...
Aren't we supposed to import statute on the basis of what they say rather than what was some sort of justification or that animated the action in the first place?
Well, Your Honor, there's a clear distinction between a factual challenge to a statute and an as-applied challenge. What we're bringing today is an as-applied challenge that as this statute in the city metropolis is applied to the homeless population, it is unconstitutional. And to your point about urination and defecation in public, it would come down to what the jurisdiction offers in terms of available options for the homeless people to relieve themselves. Are there public restrooms? Do the restaurants in the city allow them in to use the restroom? Or do the homeless shelters in the city allow them to use the restroom? If, to go towards your hypothetical, there is absolutely zero indoor area where a homeless person can use the restroom, then yes, criminalizing that action is unconstitutional because they have nowhere else to go. And there are other options that the city can use, whether it's asking that person to move on the first time they're caught doing it, providing that person with other options to go towards. So what we're dealing with here is a situation where Mr. Clark truly had nowhere else to go. And to talk about the urination defecation point, it would be the same scenario if there was nowhere else for him to use the restroom. Now, the correct interpretation of...
How do we know on this record that he had nowhere else to go?
Well, Your Honor, as my co-counsel spoke about earlier, she wasn't suggesting that there was anywhere else for him to go. He came to the United States after his home country of Atlantis was destroyed by flooding. His initial attempt to get into an apartment, a hotel, or either homeless shelter were both, he failed to do all of those things because he did not have any money, and then the shelter space was full, so he was forced to sleep under the bridge. But the record goes beyond that, Your Honor. We have data showing that from January of 2019, the homeless population in the city metropolis was too great for their homeless shelters. In addition to that, on the night that Mr. Clark was arrested, he wasn't the only person arrested under the anti-camping ordinance. There were 10 other individuals sleeping under that bridge who were also arrested. And finally, given his language at the hearing in front of the Department of Homeland Security, Mr. Clark made clear to the ICE officer that he did not choose to sleep under that bridge. He genuinely had nowhere else to go. So taking all those factors in combination, Your Honor, Mr. Clark was committing an involuntary action in a public place, and the city of Metropolis doesn't offer any other areas for Mr. Clark to commit that action of sleeping in public. Now, my opposing counsel spoke briefly about Manning v. Caldwell coming out of the Fourth Circuit, and what's the important distinction from that case is that the statute in that case did label individuals as habitual drunkards, which is not what we're dealing with here. So the appropriate case to direct your attention to is Martin v. City of Boise coming out of the Ninth Circuit, which is the exact issue in front of the court today. The court in Martin held that it is violative of the Eighth Amendment if a statute criminalizes sleeping outdoors on public property when no alternatives exist. And as I stated previously, that's exactly what was happening in Mr. Clark's case. He wasn't choosing to sleep outside under the bridge. He merely had nowhere else to go. The homeless shelters clearly cannot house the homeless population, and so it was an involuntary action that he was committing. Now,
Doesn't this place a difficult burden on the city or locality, though? Because how, the homeless population can probably fluctuate over time. How is the city supposed to monitor and know whether it can enforce its ordinances or not?
well, Your Honor, I would direct your attention to Pottinger v. City of Miami coming out of the Southern District of Florida. The district court in that case ended up issuing a consent decree where the agreements between the plaintiffs and the City of Miami was solely that the city would no longer criminalize the action of sleeping in public, and then the city took affirmative steps to combat their homelessness issue. What the city wound up doing was, as opposed to walking up to a homeless person sleeping on the street and arresting them, they would inform that homeless individual of other areas in the city where they were either allowed to camp or of homeless shelters that were available for them. Also, in Martin v. City of Boise coming out of the Ninth Circuit, the City of Boise instituted a policy where the available homeless shelters in the city of Metropolis would actually inform the police department when they became full for the night, and their anti-camping ordinance would no longer be active until those shelters became active again. So my opposing counsel's point about this slippery slope and the fact that we're asking the judiciary to step into the role of the legislature, I think is ill-founded. What we're asking today is merely to not allow states to criminalize the involuntary action of sleeping when there's nowhere else to go. In addition to that, Your Honor, the 11th Circuit has also considered this issue in Joel v. City of Orlando, and the only reason that that court held that their anti-camping ordinance, which has practically identical language to the anti-camping ordinance in this case, was constitutional, was because the homeless shelter in the city of Orlando had plenty of room for its homeless population, and people weren't taking the opportunity to go to that. The same scenario came up in Joyce v. City and County of San Francisco, coming out of the Northern District of California, where the city of San Francisco was making affirmative efforts to house their homeless population, handing out tickets to show that the homeless shelters were available, and people were choosing not to go. Mr. Clark, on the record before Your Honors, has made clear that had he had somewhere to sleep, he would have taken advantage of that. And for that reason, the night that he was arrested under the anti-camping ordinance, his sleeping under the bridge was truly involuntary.
So what would the statute have to have said in order for it to pass muster under the Eighth Amendment? What text would have to be in there different than what it was that would recognize the burdens on municipalities to prevent circumstances such as the breach of the peace that was not something that your client was involved with, but others who were in the same camp were? What would the language of the statute have to say to pass Eighth Amendment muster in order to allow them to deal with those types of circumstances and at the same time protect against the status punishment that you say happened? What would it have to say?
Well, first and foremost, Your Honor, I would ask that it wouldn't be criminalized at all, but the language of the specific statute that you're asking for would be something along the lines of, if a homeless person is approached by a police officer and they're sleeping in public, that police officer, if after speaking to the homeless person or after receiving a report from one of the available homeless shelters in the city, that officer can do one of two things. That officer can transport that homeless individual to an available homeless shelter to get them off the street, or that officer can ask the person to, quote unquote, move to another location, or direct them to an area in the city where it's acceptable for them to camp until they're able to get into a homeless shelter. What's really underlying the issue of the statutory language, though, Your Honor, is the lack of shelter space in the city of Metropolis. Going back to my discussion about Pottinger versus City of Miami, that consent decree that they issued between the city and the homeless population has decreased their homeless population by over 90%. And so it just goes to show that you don't have to allow criminalization of a specific act in order to fix the problem. And by criminalizing this act, all we're doing is taking the homeless population, putting them in jail, and requiring our taxpayers to fund however long they spend in jail. And so why not take that same funding and direct it towards another homeless shelter, or help the homeless shelters which are currently in place to be better funded and to have more beds? Now, I'd also like to talk about my counsel's discussion of Robinson v. California. This court made clear in Robinson v. California that it is unconstitutional to criminalize status. And what the court based its decision off of in that case was status comes down to something that you contract innocently or involuntarily. In the Pottinger decision, the Southern District of Florida came to the conclusion that homelessness is in fact a status, and it developed a 3-factor test in order to make that determination. First, whether or not the person chooses to be homeless. Second, whether the city provides sufficient shelter space. And third, whether the city provides any areas where homeless individuals can perform life-sustaining activities. First and foremost, Mr. Clark clearly did not choose to be homeless in this situation. He didn't come to the United States fearing persecution in his home country of Atlantis. He was forced out, put on a boat, and he accidentally wound up on the west coast of the United States. So he didn't choose to be homeless. Second, as I've said earlier, the city of Metropolis clearly did not provide sufficient housing for its homeless population. My opposing counsel made the point that most courts only rule against these statutes when the homeless population is so much greater than the available shelter space that it has to be unconstitutional, but that's simply not true, and that goes back to the Martin decision, where the numbers of homeless people compared to the number of unsheltered homeless people are very similar to this case here today. And then finally, whether or not the city provides any public areas where homeless individuals can perform life-sustaining activities. And as the record reflects, there is absolutely no space in the city of Metropolis for anyone, both homeless population or anybody else, to camp, which is defined by sleeping outdoors. So Mr. Clark satisfied that 3-factor test coming out of the Southern District of Florida, and so he did meet of having a homelessness status. Now, Your Honor made the point earlier that criminalizing the action of sleeping in public is equivalent to criminalizing the status of homelessness, and I completely agree. Justice White made a comment in his concurring opinion in Powell v. Texas that criminalizing a drug addict for drug use, criminalizing an addict for drug use is criminalizing drug addiction under a different name. Criminalizing a homeless person for sleeping in public when no alternative shelter exists is criminalizing homeless under a different name. And this would not be unfounded in the lower courts, as both Pottinger v. City of Miami coming out of the Southern District of Florida has held this way, as well as Johnson v. City of Dallas coming out of the Northern District of Texas.
I know that your argument is that this should not be criminalized at all. You do concede, though, that in the circumstance of a jurisdiction that did have sufficient shelter for homeless people, and if you had a person who chose not to avail themselves of that shelter, in that circumstance, would the city be able to enforce an ordinance similar to this one?
Your Honor, if an individual made the voluntary decision to turn down a shelter option when they are homeless, yes, that is true, and I do agree with Your Honor. However, based upon what we've spoken about earlier, in this case today, it is our contention that Mr. Clark did not have that alternative option. He wasn't approached by a police officer and asked to go to the other shelter. He didn't explicitly turn down the shelter space. In fact, he told the ICE officer during his Department of Homeland Security hearing, "Officer, I did not choose to sleep under that bridge. I would have never done it had I known the fights were going to break out. I had nowhere else to go." And that's really what it comes down to. So the answer to your question is yes, Your Honor, but based upon the facts of this case, the actions were involuntary, and so it was violative of the Eighth Amendment. Now, as I stated previously, I'm asking this court today to decriminalize the involuntary action of sleeping in public, which can extend to other actions such as eating in public, such as using the restroom in public, because it really comes down to what the city offers its homeless population to determine whether or not their actions are constitutional. In terms of the court's concern about stepping into the shoes of a legislature, I just don't think that that's going to be the case here. Solely by stripping the city's ability to criminalize an action is not stripping their ability to issue regulations that are going to allow them to control the public safety, health, and welfare of their citizens. And second, the action of sleeping in public is identical to, the action of criminalizing sleeping in public is the same thing as criminalizing the status of being homeless, which is in direct contravention to this court's decision in Robinson v. California, where it explicitly stated that it is unconstitutional to criminalize one's status.
Mr. Mooney, your time has expired.
Thank you, Your Honor. I appreciate your time.
Thank you.
Your Honor, congressional authority over immigration has been consistently described as plenary. Opposing counsel focuses on what the agency includes in its regulation, but that is not the heart of this case. This case is about what Congress has commanded. As this court held in Bowles, statutory constraints on a court's authority are Article III jurisdictional commands. And as this court said in Blake in 2016, when there's a statutory exhaustion requirement, the constitutional exception this court described in McGee in the 50s is not applicable. Second, the respondent is effectively asking this court to repeal the Real ID Act of 2005. The legislative history of that provision demonstrates that Congress enacted it to close this exact constitutional loophole that she advocates. The Real ID Act was a response to this court's decision in INS versus St. Cyr, a 2001 case where this court held that because there wasn't enough of an avenue for constitutional claims, aliens could bring habeas petitions directly with the courts and circumvent the entire administrative process. This resulted in the flood of litigation that Your Honors predicted during opposing counsel's argument. And Congress passed the Real ID Act, including that provision that provides that nothing in the act will be constrained to foreclose constitutional review, specifically to avoid that suspension clause concern and to make sure that constitutional claims are brought up in this process. And third and finally,
well, if the legislative history is so clear that that's what they intended, presumably Congress would have known how to write that into the text of the statute. You want us to take a look at the legislative history. Start with the statutory text. Tell me where in the statutory text, particularly since we know that Congress was thinking about constitutional claims and the fact that they could not preclude this court from resolving those. Tell me the place in the text that has that provision in there that says that constitutional claims are ones that both have to be brought in the hearing and allows you to make the argument that the text itself supports your position.
Your Honor, Congress does not hide elephants in mouse holes. The important thing here is that Congress has not provided an exception for constitutional claims. They are treated like all other claims. That is consistent law across administrative law as we're dealing with these statutory exhaustion provisions. We only need to look at the history of the Prisoner Litigation Reform Act to understand this. The old PLRA allowed court. I see my time has expired, if I may briefly conclude.
Yes, you may briefly conclude.
Simply put, Congress knows how to write these provisions into statutes. It's done so before. It has not done here. For these reasons, this court should reverse the decision of the 14th Circuit. Thank you.
Thank you.
Your Honors, I would like to briefly address 2 points that opposing counsel made. First, opposing counsel contends that the shelter space in Metropolis was not adequate for the number of persons in the jurisdiction. Again, the government would contend the record says nowhere how many spaces are available in the 2 shelters in the city of Metropolis. Additionally, opposing counsel points to Martin v. City of Boise for an example of where a jurisdiction was able to impose a policy where shelters could tell law enforcement whether they were full that evening, and if they were full, law enforcement wouldn't issue citations. The Ninth Circuit in Martin v. Boise found that the system did not work, and the record in Martin v. Boise is not similar to the case here. In Martin v. Boise, there were 3 shelters in the city of Boise. 2 of them one was for women, one was for men. Men had a limit to 17 consecutive days in the shelter. Women had a limit of 30 consecutive days. After 17 days, or 30 days, the only option to remain in the shelter was to partake in a religious program. One of the plaintiffs reached his 17-day max, did not partake in the religious program because it went against his theological views, was on the streets, and was issued a citation. That night, the shelters had reported to law enforcement that they were not full because they did have open spaces, but it did not mean that shelter wasn't available to the plaintiff on that night. My point in reciting these facts is just to say that the record was full in that case of proof that shelter was not available to the plaintiff, and that is why the Ninth Circuit held the statute was unconstitutional as applied to him. Further, suggesting that law enforcement must adopt a policy or should adopt a policy that shelters inform them when they're full, we see from Martin v. Boise that that doesn't work, and the jurisdiction should not go so far as to tell shelters that they can't impose certain requirements. This is, again, treading on the state's ability to experiment with the ways to regulate threats to health and public safety. Martin v. City of Boise, if it stands for anything, it's a sufficient record to show that conduct is involuntary. That is not what we have here. So I ask your honors to reverse the 14th Circuit and find that the anti-camping statute, as opposed to Clark, is constitutional. Thank you.
Thank you. I want to thank all counsel for your briefing and argument today, very well presented in this very interesting case. Court is adjourned.
All rise.
Thank you, everyone, for tuning in, and thank you to our wonderful competitors. We just gave them a round of applause here. You can give them a round of applause at home. They were wonderful. They were awesome. And so we're going to announce the other members of the Moot Court Board in a moment. Right now, the judges are deliberating, but as soon as they get back, they will announce the best runner-up oralist and the best oralist of the Myerowitz competition. So feel free to continue to tune in. We will be announcing the members of the Moot Court Board. Thanks again for watching, and thanks everyone here and at home.
So for our newest members-elect of the Moot Court Board, we congratulate you all. You guys have put in a tremendous amount of work from writing the brief all the way in January to 4 rounds of oral argument at this point. You guys have truly demonstrated why the Moot Court Board at the University of Maryland is truly something great. So our newest Moot Court Board for the 2020-2021 school year is Summer Akhtar, Kevin Albano, Jocelyn Brocato, Rebecca Carlone, Spriya Chowdhury, T.J. Creevy, Taylor Hallowell, Allison Hyde, Yoni Guggenheim, Kyle Correga, Jamie Klotzbach, Nia Lassane, Danny Mooney, Drew Needham, James Peabody Harrington, Jordan Reiger, Jeremy Ritter Wiseman, Daniel Russo, Ethan Sonnenstrahl, Evan Tassis, and Kelsey Williams. Congratulations to all the newest members of the Moot Court Board. As Bianca said, once the judges get back, they're going to give feedback to our 4 finalists, and then we're going to announce the best oralist, runner-up best oralist, best brief, and runner-up best brief. So until then, keep tuning in. Thank you.
Yeah, so I think the broadcast.
Sit down, sit down.
Okay, so we've been asked to provide some individual feedback. So I'm going to start with Judge Gallagher on my left, and we'll go this way.
All right, well, I thought you all did an excellent job. We had a very difficult decision that we had to make in terms of trying to select from 4 excellent speakers. So we really appreciate the time and energy and effort that you all put into this. Generally, and I think some folks will have some more individual comments, mine might be a little bit more general. I thought, again, that you all were great. Speed of speaking sometimes got a little bit too fast generally for all of us, even just in trying to take notes and process what you were saying. I am someone who's often at fault having a court reporter there to make sure that I'm speaking slowly enough for the court reporter, and it is something that takes a great deal of practice. So generally, I think that's something to be mindful of. But I thought you all did an excellent job working in the cases into your arguments and responding, using those cases to respond to specific questions that we were posing. I thought was really fantastic, and you all did a nice job with that. And I turn it down to my colleagues for more specific comments.
Okay. Well, I echo what Judge Gallagher said, and I would just suggest that, remember, this is an opportunity to persuade and get into a conversation with the judges on the court. And so, if you cite so many cases and speak so rapidly that it doesn't become that anymore. You want to also understand where the judges are having issues, so you want to slow down just a little bit and listen carefully to their questions. And also, some of you did this very well, listen to the questions that were asked when opposing counsel were arguing. So I'm just going to give you a little bit of individual feedback real quickly. Mr. Caraga, did I say that correct? Caraga, I'm sorry. So yeah, I mean, the idea of don't be too quickly, don't be too fast, slow down just a little bit. I thought you did a very good job answering Judge Grimm's last question in your main argument. And in your rebuttal, again, you did a good job of referring to some of the questions that were asked in the other case and forming, you listened to what was happening in the oral argument, and you constructed your rebuttal to address that, and I thought that was very good. Ms. Hyde, you did, again, at first, there was a point where you were having problem answering Judge Grimm's question directly, but you learned quickly right away, because when he was really pressing you on the factual evidence, you really answered those questions very well, I thought. I thought on the rebuttal that you gave, you did a really good job distinguishing this case from the Ninth Circuit case. And rather than trying to get 50 points in what was the rebuttal, the time that you had left? 2 minutes? And rather than trying to get 50 points in, you took one case and you distinguished it very well, and you made your point well. So you used your time really well, and I thought that was very well done. I don't know whether reserving only 2 minutes, maybe that's a good idea. But unlike the respondents, you don't really have the time to hear what's going on in the other argument before you make your presentation. So I don't know, maybe that's a strategy in the future. Maybe reserve a little more time for rebuttal. But I thought you both did a good job with your rebuttal. Ms. Brocato, I thought you did very well. You had good eye contact, and you looked at all the judges. That's one thing you want to try to do, because you may have a judge who never asks the question, but they're still, a vote. They're a judge, and so it's hard to, make sure you have that good eye contact. You did a good job of conceding points, but then returning to the strengths of your argument. One point you didn't address so well Judge Grimm's question about representation in council. He kind of had to force you to answer that question directly. But otherwise, I thought you did an excellent job. And Mr. Mooney, I thought your arguments were excellent too. You weren't too rushed in your, you weren't too rushed in your arguments. You made your points slowly, and you did engage in more of a conversation with the court. I think that was very well done. I think that when Judge Grimm asked you to, suggest what the ordinance should have said, you did a really good job with that. I mean, obviously that was something, I don't know if you prepared that, you knew that question was coming, but it was very well done. So all of you were excellent.
All right, so it was a pleasure for all of us to be here and have the opportunity. We wish that we were always so lucky to have such well-prepared advocates in the cases that we have. And those are cases involving real life and real matters. I want to take a sort of a step back and remember that when you are doing an argument like this, and you're in a court where you have some confidence that the judges have read the briefing and understand the issues and understand the law, then what you have the opportunity to do then is to persuade, to get that essence of what you want to impart upon them. And that involves what is really the art of advocacy and persuasion. Aristotle, who really said it better than anybody, and that was a long time ago, there are always three parts of the persuasion process: the ethos, pathos, and logos. Ethos is the ethical appeal of the speaker, the character, the dignity. You've seen people who come in and speak, and there's something about their presence that commands the attention. The confidence to be able to know your information so that you can express it in a way at a pace and a cadence so that they can understand it. And that ethical appeal is sort of part of the three-part. Pathos is the emotion, the underlying, where your heart gets tugged on that. And in this particular case, you had that going your way. It's sort of a sympathetic situation. And you all have to find the pathos here that sells the part of what the Congress was. And there's a great expression that's attributed to Winston Churchill. He said that tact was the ability to tell someone to go to hell in a way they could look forward to the trip. I think, Mr. Correa, that the forcefulness with which you are basically saying to the court, you pinheads have no authority to do this, Congress has spoken, pack up your bags and go home, that you could find a way of getting the importance of deference to Congress in a way that was not so perhaps forceful as the way in which you did it. It was very skillful. Your command of the law, the facts was as all of it was very, very impressive. But remember that you have to try to find in your argument something that can translate into that pathos, that emotional connection that makes it important, and perhaps wasn't something, and actually would let someone who you might be concerned that their leaning was towards the other side, that would get them to think twice about that. And the final one is logos, or the word, the logic. So ethos, pathos, and logos. The logic, of course, is how well crafted the arguments were, how well they adhered to the law, how well they followed what the statute said. All of you were very good about that. So keep in mind that this is an opportunity for persuasion and how you best craft it. That's really where the art comes in. Part of that is obviously preparation. You were all marvelously well prepared, and it wasn't limited only to the narrowness of this particular case, but you were very, very facile, all of you, at reaching in and grabbing what the cases were, distinguishing, responding. So I think that was well done. I think that of the two arguments, I think that the argument regarding exhaustion and procedure is the one that has more technical detail to it and more nuance, so there was a lot to cover. And it was an area where there were so many sub-aspects of that argument that you could both get lost in it, and you didn't. And that was very well done, because I think that was the more difficult legal argument. I'm not the sharpest tool in the shed, my colleagues I'm sure were way ahead of me, but the one that I had to spend the more time, the part that I had to read 2 or 3 times, not just once, was that part. And because it has so many overlaps over it, and I thought that that was well handled. In terms of the Eighth Amendment argument, that's really the one that had the most pathos in this, and I thought both sides did a very nice job of finding in their arguments those things which were supportive of that. And so that is, I think, something which is commending as well. Always, I mean, I vividly remember my first argument for the Maryland Court of Appeals, and I vividly remember having some time, that was very little time, and getting in there, trying to make the points I wanted to make, and there was one judge on the Court of Appeals who was just not happy at all with the statute that I was trying to defend as the Assistant Attorney General. And he grabbed me at the beginning of my time, and he just kept pulling me away from the points that I was trying to make. And no matter what I did, he kept pulling me back. And he was not even making a pretense of being very polite about it. And I kept trying to get back to my point, and he kept pulling me over there. I kept trying to get back. And finally, I ran out of time, and I was getting ready to sit down, and I will never forget, this was my first argument, Rita Davidson, God bless her, she was the first woman judge on the Maryland Court of Appeals, looked at me and smiled and said, "Mr. Grimm, I believe that before Judge Smith started questioning, you were about to make a point. I'd be grateful if you would finish that point." And I looked at the timekeeper person, and he went, and I ran with it. But you were going to get the most bullets shot at you, because you were arguing that something that really felt kind of unfair and over the top, because it's an aggravated felony. I mean, it's not even just an ordinary felony. It's bad enough, right? But it's an aggravated felony. It's like double probation, double secret probation. And you were going to get the most fire. You were going to draw the most fire. So what you got to do, and you did very well, is always answer the question first, and then you can pull it away. Because if you don't, that's why they follow up. Well, I'd like you to answer my question. But then you kept going back. And so you were swimming up you had the hardest current against you to swim up against. You were not going to be the one that could get all of your argument out in all those points. And you had to be able to be flexible. And you picked up real quick after that first time, and you did that. So that is a real challenge. It happens sometimes. But of all the sides you were going to get, this was going to be the one that was going to draw the most ammunition. So that was very well done as well. In terms of Ms. Brocato, I think that the one thing that I thought that you did very well, and again, structurally, it is sometimes better to be the second arguer, because you know what you are specifically trying to deal with. And for purposes of the petitioners, they kind of got to get it all out there, because they don't know what their argument is going to be. They don't know what your argument is going to be. They've got to try and balance making their main points with having some time for rebuttal, but they really want to make their points. You had the ability to be able to poke holes and know where you were going with their arguments. I thought that you did some excellent jobs of responding to what their points were. I would also, as another person who has burned out my share of court reporters, as a lawyer and as a judge, I have a tendency to get wound up pretty fast when I talk. Consciously try to slow down, because if they can't hear it, then they can't be persuaded by it. So you always want to be cautious of that. I thought you did a very good job on that as well. Mr. Mooney, I think you had that nice balance of being able to want to get all your arguments out, but talking in a conversational way. When you speak in that conversational way, calmly, And with authority, it underscores the fact, it shows, I'm not nervous, I know what my arguments are, I am meeting you on a plane of equality, not just trying to get it all out. And I think that that was a good, it enhanced the ethos of the presentation that you did. You also did a nice job of acknowledging, Judge Gallagher asked you a good question, and you immediately answered that question, acknowledged that you agreed with that, but then immediately spun it around and said, but this is why this is not that case. And so that is one of those things that you have to be prepared to do, which is to pivot quickly and change the argument that you wanted to make in order to address what it was that the judge had asked you for. And then I asked that question about when you have prepared a side where all of your preparation is to attack this law, to then say, so how would you write the law in a way that would survive? I wanted to see how you would handle that, and I think you handled it real well. So all of you did a terrific job. It's clear that you put a ton of effort into it. Whatever credit you got for doing that was not enough for the work that you put in. And we're grateful that we could be here today to share this with you, and we wish that the audience was as full as it would otherwise have been, but for some of the recent concerns we've been dealing with. So thanks for letting us share some time with you today.
So then we've all been waiting for.
Yeah, shut up and let us know what's going on. Give out the trophies.
So we're going to start with the best brief awards and the runner-up best brief award. These two competitors, we have Taylor and Jordan here. They've put in a tremendous amount of work writing the briefs. You all have. They've demonstrated proficiency in written advocacy above those of everybody that's competed in this competition. You guys should be extremely proud of yourselves. The award for runner-up best brief goes to Jordan Reiger.
You're not supposed to do that.
No handshakes.
No handshakes. We're going to take a picture.
That's worth getting compromised for, right?
Sure. And then our best brief award winner for the 2020 Myerowitz competition, Taylor Hallowell. And now for the Best Oralist and Runner-Up Best Oralist awards. For Runner-Up Best Oralist, Allison Hyde. And for the Best Oralist Award for the 2020 Myerowitz competition, Daniel Mooney. If you guys would like to take pictures with the judges, we have Professor DeSimone, our faculty advisor, who's going to give closing remarks. Please feel free to stick around. Thank you again to everybody who tuned into our live stream. We appreciate all of the hard work that was given by our competitors, the Moot Court Board, our professor, Professor DeSimone. And let's give one last round of applause for our judges. Thank you.
Congratulations.
Thank you.
Great job.
I do want to, I think we probably are not going to do pictures with the judges. Unfortunately, I don't know how you all feel about that one way or another, but.
I don't care.
Fine with me.
I'm happy to do a picture.
Okay.
We won't shake hands, we'll just take pictures.
That's right. You had to have wide angle lanes because we have to stand 6 feet apart, as the governor has said.
How do you, I'm not in charge.
Stand right here so nobody has to touch.
Viewers, are you able to take?
Thank you, you all were really wonderful. I know, we normally would shake hands
Thanks
in
very
this
much.
circumstance.
I
but
just
yes.
know
Social distancing.
how much time it went into doing all that stuff.
Yes.
So that was-
And you all were so close.
Right, it was,
Very-
it
Oh,
was
yeah, I
a
mean,
very
it's just-
difficult decision.
They almost don't have the instruments.
And someone needs to signal us here.
All right.
Press conference.
So start with them.
Yeah, where to look, all right.